Hello everyone and welcome to today's Mondac webinar in association with Taylor Wessing, who will be providing you with the HR Toolbox for running your German operation successfully. My name is Dan Sampaio and I'm joined by the brilliant Friedrich Goker and Michael Beer to take us through today's discussion. With extensive experience and track record of successfully advising hundreds of foreign companies setting up their business in Germany, Taylor Wessing, a known go-to legal expert for navigating the complexities of the German market. Taylor Wessing helps foreign companies on a daily basis to set up their operations in Germany and standing by their side during expansion needs. Now, before I hand over to the panel to begin today's webinar, a quick housekeeping item. You can submit questions to our panel by typing them into the questions pane of the toolbar on the right-hand side of your page, and we will endeavour to answer as many of those questions as possible during our Q&A session. It's now my pleasure to hand you over to Friedrich and Michael to begin. Thank you.
Hello, everyone. Thank you, Dan. Thank you, Aaron, for the kind introduction. On behalf of Taylor Wessing, my colleague Michael Beer, and myself, Friedrich Göcke, welcome you to our seminar on how to best lead your German organization from an HR law perspective. Some quick admin notes from my side. We will have a 40 to 45 minutes presentation and a 15 to 20 minutes Q&A. If we do not manage to answer all questions in time, do not worry. The answers to the open questions will be submitted to you as a sort of debrief along with the presentation. So hopefully nothing gets lost and no question remains unanswered. Before we start, to all of you who are already invested in Germany, thank you for doing business in our wonderful home country. And to all of you who are still in the process of deciding whether Germany is a great place to do business, I want to assure you it is. Apart from these impressive landmarks you will find on the next slide, we in Germany are in the heart of the EU, which is the second biggest economy and the second biggest market in the world. Germany itself is the third largest economy in the world with one of the best, if not the best, infrastructures in the world. Germany is an easy country to root for, I would say, as a proud compatriot. And of course, you can root for the German national football team to win the Euro 2024, which we are hosting starting next Friday. But more importantly, and for our purposes, you can root for the German workforce. The German workforce is one of the most skilled workforces there is, with more than 82% of people having either finished vocational training or a university degree, and the German workforce is considered top 10 in innovation skills as well. So no obstacles to have a thriving business in Germany? Well, almost. From an HR perspective, you will have to find a way to kill the paper tiger. The paper tiger, for the purposes of this webinar, is a symbol for the democratic hurdles and the high employee protection standards you will find in Germany. Those, of course, do serve a purpose, but when it comes to growing your business and making some tough decisions on the HR side, those standards may sometimes give you headaches, and we will now show you some ways to deal with these headaches and to find the best results for your organization. That's what we're here for. We hope to give you some guidance on how to navigate the most important HR challenges, which we find the most pressing ones for 2024. We will talk about, so to speak, the original paper tiger, meaning actual paper-related formalities before, during, and after the conclusion of employment. Michael will provide you then with some insights into remuneration practices as well as regulations with regard to working time. And then I will close the session by giving an overview and some best practice advice on how to end an employment relationship in the face of tough dismissal protection in Germany. So let's take on the paper tiger. Why do we start with such a rather boring and very formal topic? Because I think it demonstrates quite well to you that the German legislature means well in protecting employees, but sometimes it manages to confuse even the most experienced HR people like many of yourselves are. To give you an example, if you Google, does an employment contract in Germany need wet ink signature? I'm pretty sure you will get conflicting answers. Sometimes you get a yes, sometimes you get a no. The correct answer is, from a legal perspective, no, but it's a no but. It is correct that under German law, you can enter into an employment contract legally by using email or DocuSign or even WhatsApp or, let's say, sign language even. There is no formal requirement whatsoever when it comes to entering into an employment relationship. But there's the but. There is a written requirement for the so-called essential terms of employment according to the German Evidence Act. These essential terms of employment must be handed out in writing, meaning with a wet ink signature on the first day of employment latest. Here, the signature of the employer is sufficient. So you may ask, isn't that kind of an unnecessary double move on a bureaucratic side to have two documents, the draft contract and the essential terms of employment? And I would say, yes, you're right. The contents of the employment contract do overlap with the contents of the essential terms of employment. So if you manage to have the draft employment contract signed with wet ink before the start of employment and have it submitted before the start of employment, you're all good. And no essential terms of employment are needed, as they are all included in the written and wet ink signed employment contract. But as it is often the case, you don't want the paperwork and the formalities to stand in the way, and you want to move forward with the hire quickly. So we advise you to use the following steps. First, you come to terms with the candidates economically and commercially. Second, you DocuSign or email the contract beforehand. And third, you print out the DocuSign contract and sign it. This is necessary with a wet ink signature to give it to the employee during the first day of employment, or you take care that it gets sent over to him for the first day of work. Please be aware that the German Evidence Act, that means the law that asks for the wet ink requirement, was amended in the summer of 2022, much to the irritation of HR representatives like yourself. The amendment provides for even more content to be included into the employment contract, and more importantly, it imposes a fine of up to 2,000 euros if the formal requirements are not met. So to sum up the key points when it comes to correctly formally starting an employment relationship, if you have a high potential candidate, let's say for a sales job, and he wants to start working on very short notice, let's say within a week, he wants to sign immediately, do it. You go for it. You sign him immediately, but please don't forget to hand him a signed version of the employment contract as soon as possible, latest at the first day of onboarding. If your German employees have an employment contract that is older than 2 years, there is a certain chance that the contract templates are not compliant with the German Evidence Act. As I told you, it was renewed 2 years ago, so you should consider getting that fixed in due time. Third, and most importantly, there is no rule or no recommendation for right course of action without an exception. Please be aware that the recommended procedure is available for permanent employment contracts only. If you have a fixed term contract, please be aware that the employment contract must be signed in wet ink by both parties before the beginning of employment. This is vital because if you don't have the contract signed in time, there is an immediate danger that the employment becomes permanent against the will of the employer. Similarly, please have the contract signed in wet ink before the first day of employment in case there is a post-contractual non-compete, which are especially relevant for sales representatives and sales employees. Those are a tricky subject in itself, but also those post-contractual non-competes need to be agreed upon using wet ink signature. Please note one thing. I hope you're not yet tired of the German bureaucracy. help is on the way. There is concrete legislative efforts to make this process easier and more up to standard with international business. There's a genuine hope that by fall this year a new law is passed that provides for an email-only process when it comes to entering into an employment relationship, or at least an electronic signature-only process. But until that lucky day comes, please stick with our recommendation. Then you have a good chance to manage the paper tiger. So we have established sort of no shortcut rules when it no shortcut rule when it comes to wet ink signature for fixed-term contracts and for post-contractual non-competes. Sorry. Please note that the same no shortcut rule does apply when it comes to terminating the employment, be it through a one-sided notice of termination, be it through mutual termination agreement. For the termination or the agreement to be valid, you need to have wet ink signature as well. Please understand from our lawyer's perspective that formal mistakes are often the low-hanging fruit for opposing counsel in an unfair dismissal litigation. I would say from my experience, in 4 of 5 or in 3 or 4 dismissal protection lawsuits, opposing counsel tries to exploit a potential formal violation of the dismissal and tries to score some points there. When it comes to formalities, we would recommend paying attention to the following 4 points. First, have the termination notice signed by the right legal representative of the employing company. Second, have the termination notice signed in blue wet ink. Third, take care that the termination is submitted in due time. And 4, have a delivery process in place or have your lawyers manage the delivery process for you. As to point 1, have the termination signed by the right person. We strongly recommend this right person being the legal representative of the employing entity, meaning mostly the managing director, who often has a managing role with the foreign parent company. It is possible to have the termination notice signed by someone else. However, we do not recommend it, as in most of these cases, the original power of attorney document would have to be delivered alongside the termination matters, which would then again require the signature of the legal representative. So to sum it up, there is little to gain when using someone other than the legal representative as signatory. As to point 2, it's quite simple. Use wet ink and wet ink only when signing the termination notice. As far as the time management and delivery process is concerned, please note that oftentimes delivering a termination notice is quite time sensitive, as most employment relationships can be terminated by the end of a month of serving a certain notice period. That can be 1 month, that can be 7 months, it's mostly in between. It may therefore be crucial that the termination notice gets delivered in time at the end of the month, so that the employee is not getting an extra month of employment due to bad time management, which would be, of course, costly for the employer. As far as process is concerned, we always recommend that delivering the termination notice either in person or via courier, so that we have an exact documentation on the time of delivery. Please note that the courier should, or the messenger, the one who delivers the notice, would have to read the termination notice himself, then put it in the envelope himself, and then seal the envelope himself, so that later he can attest to what document exactly he has delivered. Delivering means sending it out to the person, to the employee in question, or putting it in a letterbox. Of course, we as your HR lawyers would support you in delivering the termination notice with the assistance of our paralegals or some other experienced employees. So now we have gotten the rather, let's say, dry formalities out of the way. Let's talk more on the business side of the employment relationship. And Michael, what can you tell us about remuneration practices and about working time issues in Germany.
Right. Thank you, Friedrich. So let's take it away. For those of you who have already set up shop in Germany or are planning to hire employees in Germany, it's always good to know on how these remuneration packages are constructed in Germany. And for this, let's start off by taking a look at the general landscape of the remuneration schemes in Germany. As Friedrich pointed out correctly, German workers, they have a very high level of education and usually are trained very properly. However, in Germany, there is, at least in recent years, there is some shortage of skilled workers, leading to a war on talent, especially in certain industry sectors such as the IT or big pharma industry. Therefore, for those of you who want to hire employees in Germany, be aware that there will be a war for talents, and for this we want to give you a short overview on what to offer your employees and what will be expected by your employees. So let's start this off. Generally, Germany is not, of course, not a low wage country. Wage levels are generally at a very high level. So that there is a minimum wage act in place, which has recently been updated, and the minimum wage has been increased to an hourly rate of approximately 12.4 euros per hour. In Germany, any remuneration is paid on a monthly basis. Any bi-monthly remuneration schemes or even weekly remuneration schemes that are common, for example, in the US, are quite uncommon in Germany and will be putting your employees off. So any of your German employees will be expecting a monthly payment. Usually payment will be due at the end of a calendar month. And now let's take a look at how those remuneration packages are composed in Germany. Next slide, please, for this. So generally, German employees are paid by a monthly fixed salary and in a monthly gross remuneration. This gross remuneration is usually or otherwise, let's say the other way around. So the monthly gross remuneration is also including any form of social security. So when making the monthly gross salary remuneration, the salary contains all of the employee's social security contributions. So by making the gross remuneration, the employee is fully socially protected. So any gross remuneration includes the employee's unemployment benefits, the employee's pension insurance, medical and health insurance, as well as nursing care insurance. And those social security contributions that are used to pay for these benefits are borne half by the employer, half by the employee. So therefore, when making the gross remuneration payments for an employee, you don't have to worry about additional social security. So you don't have to carry out pension schemes, health insurance schemes. Instead, the employee is fully covered. However, of course, you are more than welcome to offer any additional company pension schemes to your employee. However, please note that it won't be expected by your employees, as the German Social Security scheme is very powerful and covers for a very high standard of social protection. In addition to the monthly base salary, employers often do offer a variable remuneration component, and usually it is common to offer such remuneration for your white-collar workers. We don't see such variable remuneration for blue-collar workers very often. So in practice, I'd say with respect to white-collar workers, I'd say half of them will be getting an additional variable pay next to the base salary. And it's at the end of the day, it's up to you and it's up to the employer's discretion. So we have a lot of clients, they go into the war of talents by offering a very high base salaries and then are not offering a variable pay. However, the other way around is also perfectly fine. When offering these variable remunerations, usually there are three types or three options how to turn this around. most common option is to agree with your employees on a target-based remuneration scheme. For this, at the end of a calendar year or at the start of the employment relationship, one would usually agree on certain targets with the employees, and then at the end of the calendar year determine whether the employees have reached these targets, and then see whether according to the target achievement the variable pay is due. That's the most common option in our experience. And usually in this option, the employer and the employee do agree on a fixed sum of the target bonus. So usually at the beginning of a calendar year, you are agreeing on, let's say, 20,000 euros gross in case the targets are reached. And then depending on the target achievement at the end of the year, the employee gets paid this target bonus. As an alternative, and this is more common in UK and US law especially, is a discretionary bonus. With this discretionary bonus, the employer has some sort of flexibility, and basically the employer is then able to award a bonus payment at his or her discretion at the end of the calendar year, and this bonus payment just has to be and has to be fair to the employee. So this gives you some sort of flexibility. And the second option for these variable pay schemes, of course, are commission payments. I mean, it comes without saying that this is pretty much self-explanatory, and is often used for employees who are rendering their service in the sales department. So usually the employees are awarded a certain percentage of the revenue generated by them. With respect to all of these variable pay schemes, bear in mind that there is very strict case law on what you're allowed to agree and what must not be agreed upon. So usually what we often see with respect to our international clients, they have some sort of bad leaver clauses, giving the employer the right not to pay out any variable pay in case of a bad leaver event, or trying or having like the possibility to reduce any variable pay in case of illness that is beyond the regular amount. Bear in mind, such clauses usually don't or are not considered lawful in Germany. So when coming up with these variable pay schemes, it is important to have these schemes properly drafted. Otherwise, in case they are not properly drafted, usually German labor courts have ruled that in this case, the employees are to be awarded basically the target bonus or the bonuses on target achievement of 100% as some sort of damages. Okay, when thinking about Germany and the remuneration schemes, one also has to bear in mind that next to the base salary and next to any of the variable remuneration schemes, there isn't anything else that employers usually need to offer, because Germany has a very high standard of statutory paid time off schemes, which we are taking a closer look right now. So in principle, Germany, as you may have known, is famous for a very generous vacation scheme. So there is a minimum vacation entitlement based on the average working days rendered per week by your employees. In case of a 5-day working week, which is like the standard practice, an employee is to be awarded at least 20 statutory vacation days per year. However, as Germans are very fond of their vacation, it is common and it is expected by your employees that they are granted additional bonus vacation days. So standard practice is to award your employees a total of at least 28 to 30 vacation days per year. And in addition to this, in the war of talents, we see many clients who have introduced a take what you need vacation policy just to win over clients, because bear in mind the 30 days of vacation per year is pretty much the minimum your employees will be expecting. Next to the vacation days, there are also a lot of public holidays in Germany, and they are amounting dependent on where your employee lives, to 9 to 13 days of additional statutory vacation days per year. So for example, the state of Bavaria is most famous for its statutory vacation days, and any employee rendering his or her service in Germany usually benefits of 13 public holidays in addition to the statutory and contractual vacation days. Further, in certain states, there are also statutory claims for professional training. So in, if I remember correctly, 14 of the 16 federal states in Germany, your employees can claim up to 5 educational vacation days per year, and they will claim this. Next to vacation days and public holidays, there is a statutory sick leave scheme. So for your employees, in case they are falling sick, they are entitled to receiving their continued remuneration for a maximum period of 6 weeks. So this basically means that you as the employer, you have to pay your employees irrespective of them not rendering any services. So that's stipulated by law and there is no way around it. Next to the statutory sick leave, there is also a very high protection on employees during the maternity and parents. So in principle, any female employee who is pregnant is or falls under a fully paid ban on working starting 6 weeks before the expected due date, and this statutory maternity leave lasts up to 8 weeks after the actual birth date. So in principle, any mother is entitled to further 14 weeks of paid maternity leave. However, this maternity leave, you as the employer, you have to upfront the maternity leave payments and you will get reimbursed by the state. After the maternity leave, any parent can ask for parental leave, and during the parental leave, any employee can be exempt from working for a total of up to 36 months. So this is the parental leave. During this parental leave, however, the employment relationship is put dormant. So you as the employee, you don't have to make any payments. And the state will then step in and will pay the employee a parental leave allowance up to 2,100 euros in case an employee makes less than 175,000 euros gross per year. For any employee making more than that, no state allowances are paid. Last type of pay time off, which also is provided for in Germany, is the statutory care leave. So in case you have a close relative who is in need of care, any employee can ask the employer to be exempt for work for a total of 6 months. So basically, these are the statutory types of leaves. And in our daily practice, we are experiencing that the German employees are claiming or asking at least for an additional form of leave, and this is like sabbatical. However, there is no statutory claim for a sabbatical. However, in the war of talents, any employee working in a sector with a shortage of skilled worker is expecting that the employer, after a certain number of services rendered for this employer, is at least open for a sabbatical. So this is something you can keep in the back of your mind when having like negotiations with their employees, that this is something they might be bringing up to the table. So I know we have told you a lot on all of these statutory entitlement and what is expected in Germany, and let's sum up this segment with a short summary on what you need to offer your employees. So it's comes without saying, so a monthly fixed salary. Then for your at least white-collar worker, you should be coming up with a variable pay scheme, either target-based remuneration or at least a discretionary bonus. And you need to have in the back of your mind then when calculating all of your costs for your employees that there is a certain number of additional leave days you will be obligated to pay your employees without receiving any services in return. And this is due to the sick leave payments and due to the extensive vacation days in Germany. Okay, so this has been with respect to remuneration, and let's move on with another hot topic in Germany you need to be aware of, and this is keeping track of your working time with respect to your employees, because this is something which is discussed very vividly at the moment. So basically in Germany, what we have in place right now is a very outdated Working Time Act. So right now, the German Working Time Act basically stipulates that the regular number of hours during a working day must not exceed 8 hours per day. It can be, in certain cases, it can be extended up to 10 hours per day if the average working day does not exceed 8 hours over a period of 6 months or 25 weeks per year. In general, all working days or all weekdays are considered working days with the exception on Sundays and public holidays. Bear in mind, on Sundays and public holidays, the employee must not render any services unless there is a legal exception for it. So this being said, your employees usually will expect a working time scheme or contractually working time scheme of 40 hours per week, and these 40 hours usually are to be distributed on 5 days per week. With respect to working time tracking, right now, the German Working Time Act, again, which is very outdated, wants you only to track overtime hours. Next slide, please. And hours worked on Sundays or public holidays. So this is why at this point in time, most of our German and international clients don't have in place any working time tracking. Usually even the legal obligation to track working time going beyond 8 hours per day is not followed, and usually German labor authorities, they don't fine it at this point in time if you're not complying with this. However, and this is the big however, in recent months there has been a ruling of the highest German labor court, the German Federal Labor Court or Bundesarbeitsgericht, who recently has ruled that the employer is obligated to track the German or its employees' working times just to see whether there are any occupational health and safety risks. And the reason behind this is basically as follows: only an employer who knows how many hours its employees are burning, only this employer can check whether there are any health risks for its employees. And after this ruling was passed, the German legislator, for the first time for decades, knew and took the hint and started working on a new Working Hours Act. And this Working Hours Act right now, it's heavily discussed within the German government and within German parliament, and it has not been introduced by now. However, it will be clear that in the next couple of months there will be a legal obligation, and not only an obligation stipulated by case law, but a real legal obligation laid down in legislation that will require any employer to have its employees track all of their working time electronically. So for those employers of you who are already in Germany and are employing employees in Germany, you should be aware that I'd say in the next month, next half year, next year, there will be law introduced that will require you to introduce a working time recording scheme. So this is something you should take an internal note. You should follow German legislation, and once the new Working Time Act is introduced, you will be obligated to introduce such working tracking system. So after having like the overview on the working time stipulations, let's bring up another hot topic in Germany, and this is paying goodbye, getting rid of your employees. Friedrich, take it away.
Yeah, so I understand. Ending an employment relationship is, of course, never an easy decision from an emotional point of view, from an HR point of view, and in Germany, especially from a legal point of view, albeit it's a necessary one at times. And from a business perspective, especially if you come from a country with a lower dismissal protection, employee dismissal protection may actually be the biggest cause of concern, because you may have an employee, even a high ranking one, who does not perform up to standards and costs you money, and you need to find a way to part ways with them. Sometimes, of course, you will agree to part ways mutually rather quickly. Other times, especially when there are prior conflicts, you may have to take the hard route and go for the option of a one-sided termination. So let's start with the easy part. If the employee is within the first 6 months of his or her employment, there is only a bare minimum of dismissal protection. Maybe it is dismissal protection from discriminatory dismissals. Otherwise, it's basically free hire and fire, so to speak, for the first 6 months. So have yourself or your HR representative mark the end of the 5th and the middle of the 6th month of employment with a bright color in your calendars, because in a couple of weeks the employee will have rather robust dismissal protection. The same will apply if you have a small company, a small entity of 10 or less full-time equivalent employees. Here it's the same as I told you before. There is only a minimum of dismissal protection. But apart from these rare cases, the walls of dismissal protection, so to speak, are very high and they are very robust. So how to get through them? In our experience, and I think, Michael, I speak for you as well, the deciding factors in successfully parting ways with employees is only to a small portion the strength of the legal argument, so to speak. If you had to put a number on it, I would say it's roughly a third the legal argument, 1/3 negotiation tactic, and 1/3 it's a mindset. So let me explain what I mean by that by starting at looking at the actual reasons to lawfully terminate the employment relationship. A dismissal will only be valid if there is one of the following 3 reasons for justification applicable in the case at hand. That means if there is a conduct-related reason, a person-related reason, or an operational reason. Please note that for all these reasons that can potentially justify a termination, the principle of last resort applies. That means that all alternative acceptable measures to keep the employment going must be exhausted before taking the route of dismissal. So let's go through the reasons real quick. Conduct-related reasons, you can imagine it's basically if the employee commits a breach of contract, if he can be late, he can abuse a colleague or a superior verbally, or a customer, if he documents his working time wrong, if he disobeys directive, and so on. Please note that in most cases of conduct-related dismissals, there is an alternative measure to be exhausted before the termination, which is to render a formal warning to the employee with the hope that his conduct changes for the better. If there has been no prior warning with regard to a similar conduct, a conduct-related dismissal is far easier to argue for. There are some massive violations, for example, very hard forms of harassment, of violence, of theft, in which there needs to be no formal warning and you can terminate the employment contract immediately, maybe even for cause, meaning the notice period does not have to be observed and you end employment right away. It's a little bit different with person-related reasons. This is, I think, 95% of these cases are sickness cases, cases of continued sickness. A written warning does not make sense here because it is beyond the employee's control whether or not he or she is sick. Please note that since all measures have to be exhausted, you have to maybe change the tasks of the employee, lighten the burden, so to speak, change the work environment, offer him some means of resistance before you even consider a dismissal for person-related reasons. I'm sorry. Please, as a rule of thumb, you can think about these person-related related dismissal when the absent time is 6 weeks or more for an extended period of time, mostly 1 or 2 years. The dismissal can also be for operational reasons. I think this is pretty self-explanatory as well. You will have to prove that the position occupied by the employee for now and the foreseeable future does not exist anymore. This can be the case with a redundancy or if an operation is closed altogether. Also, with the operational reasons, you have the principle of last resort, so you will have to check for alternative employment, be it in another position of the company which may be vacant or become vacant, or be it by reducing the working hours so that budget needs are still fit, not when you terminate him, but if you reduce the working hours. So far so good. That's the, how we call it in Germany, gray theory. But how to actually approach a case when there is, let's say, some reason for dismissal, but it's simply not enough to constitute a socially justified reason for termination. The first thing, I think, Michael, I speak to you as well, when we are engaging with mainly UK and US clients, they will ask us the first question, how much do we need to pay him to leave? So this is why we actually named this paying goodbye. And according to the German law, this is the wrong question, because dismissal protection, the idea behind the German law is it's a black and white thing. The termination is either valid, then the employee has to leave, or it is invalid, then the employee is allowed to stay. But in practice, 80 to 90% of dismissal cases are actually ended through a settlement, which means the employee leaves, and the only question is how much do we have to pay him. So the question asked by the client is actually the right one. So from that point on, it's basically negotiation and the legal argument that, of course, we have to review, and of course we have to be laser sharp in it. The legal argument presented mainly serves the purpose of improving your position in the negotiations. As lawyers, we will have to find a way for you to find the balance between making it very clear that it's the company's wish towards the employee to move on and still keep the atmosphere in a matter of fact way, so not to lose common ground that is needed to find a solution in the end. Depending on the strength of the legal position, the likely outcome will be a settlement between 1/2 and 2 monthly salaries per year of service. This, of course, is only a rough estimation, and when you go to a labor court hearing, this is the number, this is a corridor, 1/2 to 2 monthly salaries the judge will likely work with, and he will indeed work with you to find a settlement, because let's face it, the judge has a full desk as well, and he has no interest in formulating and writing out a ruling. So he will help you maybe come to terms with the employee. So let's put it to use. You have let's close out with a concrete example. You have the employee who is underperforming, but not to an extent that breach of contract can be argued, and you have a vital business interest to part ways with him. The question will be, that is basically the delta you're standing in front of. do you move forward with the termination, even though it may be risky, or do you, let's say, swallow the pill and keep the employee? And in our experience, the answer is almost in all cases, you move forward with the termination and you try to come to the agreement. And from a tactical point of view, you have two key advantages as an employer that we will put to use for you. The first one is a pretty simple one. You as the employer play a bigger role in the employee's life than the employee plays in your day-to-day life. That means you are more important for him than he is important for you. Sounds hard, but that's the way most negotiations go, and that's the premise on which most negotiations are based and should be based from the employer side. And second is you have certain tactical buttons that you can press to push, to de facto push the employee out of the company step by step. The most effective way is to refuse to let him work, because in this case he may file a claim against you to pay for the remuneration, but, and this is the key for you, any payment you would have to make can be offset against alternative income that the employee fails to earn in the meantime. And at that point, the employee is kind of forced to look for alternative employment just to prove I tried to earn other income, but I failed. And in this process, he will have to look for new employment, and he will then, come to the slow conclusion in our experience in most cases that it is the best way to accept an offer that is presented to you by the employer. So to sum it up, if you have the right tactical guidance, and if you have that is what I meant when I said before, the right mindset, if you have sort of the stomach to go some distance in the negotiation, in the end, the question will finally be, how much do I have to pay him for saying goodbye? And with that, I thank you for your attention, and I will open the Q&A session. Michael?
Right. So thank you very much. We have already seen there are a lot of questions posted in the chat. Thank you very much for your participation. So we have 12 minutes, at least 12 minutes left to answer most of the questions. And well, I'd say we start right away with it. So Nikki asked, are there specific requirements when conducting performance improvement plans with employees based in Germany? So this relates what Friedrich has already or just told us with respect to dismissal. So in Germany, usually those performance improvement plans, they are, according to case law, they are a requirement before you can even go ahead and issue a legally valid termination for bad performance. In Germany, unfortunately, there is no statutory law setting out these requirements. However, case law has come up with at least 3 requirements any performance improvement plan needs to cover. First requirement is that the performance improvement plan needs to cover a period of at least 2 to 3 months, and thus giving the employee a real possibility to improve his or her service. So at the span of the performance improvement plan needs to be 2 to 3 months. Second requirement is when coming up with this performance improvement plan, the targets the employee needs to achieve and need to be very specific, and they should be laid down in writing in a written performance improvement plan. And when coming up with these targets, they do need to be achievable by the employee. So you have to apply your reasonable discretion when coming up with the tasks and targets that the employee needs to fulfill in order to improve his performance. And third requirement is you need to have regular check-ins with the employee during the performance improvement plan. So when giving him or her the instructions of the tasks he needs to carry out in order to improve his performance, usually it is recommendable to have at least bi-weekly check-ins and sit-downs with the employee and track whether he is on the right path in achieving the task set out by the employer, and if not, the employer is obligated during the performance improvement phase to help the employee and give him or her further assistance on how to improve his task. Okay, Friedrich, do you want to take the next question?
Yeah, perfect. The question is on the redundancy point. If the parent company had legal entities in other countries, would the requirement to seek alternative employment to avoid redundancy extend to entities outside of Germany within the parent company? The answer is no. You have, let's say, 3 dimensions that you can look into. You have the dimension of the operation, this may be a factory hall, the legal entity, which may extend to, you know, two factory halls, for example, and then you have the group, the parent company, that are somehow linked legally. And when it comes to looking for alternative employment, you look into the second dimension. You look into the dimension of the legal entity. So if you have, let's say, a German GmbH, with the parent company of which is an American or UK limited company, you will just have to check the German GmbH for alternative employment. There may be rare cases in which it's stipulated in the employment agreement that you have to look for alternative employment within the group, but this is really rare, and the normal case is you have to look within the legal entity only.
Okay, so next question relates to the very favorable public holiday scheme in Germany, and it's a good one. In terms of the public holidays in Germany, would legislation allow for employers to give individuals the option to flex when they take their bank holidays, should they wish to opt to do so? We offer flex in the UK. Is this possible in Germany as well? So I do like this flex option. However, it's not possible in Germany at all. So these statutory holidays, there is no way like to opt out or to switch the statutory holidays to another date. Instead, once a statutory or public holiday occurs, the employee is not obligated to work. And usually German employees, they are not used to any of these opting out or flex schemes, because bear in mind, once such public holiday occurs in Germany, basically public life is shut down, and your employees will spend time with their family and have some time off.
Yes. Thank you, Michael. I will answer 2 questions because they're very closely connected. Will the forthcoming legislative changes relating to changes to signature likely move qualified electronic signature as common in other European countries that can be utilized in conjunction with DocuSign? The answer is yes, hopefully. As it stands now, you know, as some of you may know, we have a 3-party coalition in Germany, and the minister who is in charge of changing the rule is of the Liberal Party. So there is maybe a tendency of giving the companies more leeway. So the current state of the law would actually be that you can even enter into employment contracts via email, but I'm pretty sure that the DocuSign level should be the level where we will meet with the other coalition partners. But I see Michael shaking his head in disbelief a bit. we had as lawyers, let's say 2 or 3 instances in the last years when we were hoping to give to our clients the positive news that we have some debureaucratization, is that a word? We have the word in Germany, so pardon the English here. But if we have some ways to ease the bureaucratic pain. And last time they changed it for the worse. As I told you, on 22, they wanted to change the German Evidence Act, which provides for this red ink thing. And what they did is they put a fine in it, and they put more requirements in it. So let's see. I hope that at the end of the year, to the one who asked the question, we will have a nice beer together and talk about how easy it is in Germany to enter into an employment contract and to, well, have killed the paper tiger. So to come back to the theme of our seminar. So if you also ask, if documents aren't signed in blue ink, what is the potential risk in terms of using validity if black ink is used? This is just, the blue ink is just a side note. It's wet ink. It's the important thing. We recommend the blue ink because in a colored copy you see the difference from a copy. Sorry, in a black and white copy you can see the difference between the original and the copy. So black ink, blue ink is always to serve the purpose, because you don't have to serve to the employee the notice, a copy of the notice or a scan of the notice. You always have to serve the original, and the originality is best demonstrated by using blue ink, because it's it shows in the copy that it's the original. Oh, better than black ink.
Okay, perfect. We have a few minutes left. I'm taking a look at Dan. Dan, one further question, because it's a good one, and it certainly will be of interest to most of the participants. So Numi asked, if we only have one person employed in Germany, does that mean we fall below the threshold of 10 employees, or does it count the whole firm globally? And this is a very important question. So with respect to the applicability of the German Dismissal Protection Act, it is decisive of the number of employees you're employing locally on the ground in Germany, irrespective on the number of employees you are employing worldwide or even in different entities. So bear in mind, you only have to count the employees on the ground in Germany. And this is of special interest for employers or companies starting to setting up a shop in Germany. So bear in mind, for the first 10 employees you're employing in Germany, none of your employees are enjoying dismissal protection. However, once you are going beyond 10.2 employees in Germany, the Dismissal Protection Act will become applicable, and you will have to deal with all of the mess Friedrich just laid out. Perfect. So I'd say this concludes the Q&A session. Dan, up to you.
Michael, I think that we may have one question remaining from Megan.
Right.
Maybe able to see it. It's about employment contracts. I don't know if you saw that.
It's a quick one. If you need to update an employment contract to be compliant with the changes to the Evidence Act, is there an opportunity for the employee to renegotiate the terms of the agreement, or can the employer just say this is a real legal requirement? You have two options as an employer to be compliant with the Evidence Act. You can either write a new employment contract, which you hand to the employee and say, please sign it because it contains the legally relevant information and it's new and it doesn't change anything from the economical perspective. But what you also can do, if the employee says, I only sign it if I get A, B, and C, you can say, okay, you don't have to sign a new contract. I can just hand over you a sheet with the employment conditions, which is in accordance with the Evidence Act, and that covers that obligation. So there is no hidden door for the employee to renegotiate. So Michael, I give it to you for the closing remarks. And thank you from my side. It was a pleasure doing the Q&A with you.
Okay, perfect. So thank you very much. So I hope we gave you an overview on killing the paper tiger in Germany. You enjoyed our session. I mean, it comes without saying, you're seeing very nice photographs of the both of us. So it comes without saying, in case you have any employment needs for Germany or any needs for Germany in general with respect to the legal situation, don't hesitate to reach out to us. You can see our contacts right there. And of course, you will be receiving the PowerPoint presentation right after the session. Now, back to you, Dan.
Brilliant. Thank you very much for that, Michael. Firstly, thank you very much to our audience for that Q&A session. Lots of great questions in. Thank you very much for sharing your afternoon with us. Friedrich, Michael, thank you so much for your willingness to answer those questions and share your expertise, and of course, for your time today and your presentation. We've really enjoyed spending the hour with you. So thank you very much. Hope to see you all again soon. Have a lovely rest of your day. Goodbye.
Thank you
Bye,
so
guys.
much. Bye bye, everyone.